First of all, I should mention that the Office of the Labour Commissioner plays a pivotal role in the resolution of labour disputes, and the disputing parties expect to have their disputes resolved promptly so that they can know their fate and move on with their lives. We must always remember that we are dealing with people's livelihoods, their bread and butter, and we cannot allow the system itself to become a contributing factor to prolonged suffering. The directive was prompted by a growing concern over the increasing number of postponement requests that have been negatively impacting the timely resolution of labour disputes. And this trend has led to significant delays at both conciliation meetings and arbitration proceedings. And it undermines the efficiency and credibility of the labour justice system. Therefore, the Office of the Labour Commissioner introduced this directive as part of a broader effort to restore sanity, discipline, and accountability within the dispute resolution process so that labour matters are resolved expeditiously.
Now, the office mentioned an increase in postponements at conciliation and arbitration stages. Just how serious has this problem become?
As the head of our institution, I closely monitor the weekly reports submitted by our arbitrators, which detail the status and outcome of their assigned cases. I also engage each arbitrator on one-on-one to keep track of pending cases from the previous financial years. Over time, I started noticing a recurring trend, which is an increasing number of matters that were being postponed simply because parties indicated they were not ready for arbitration. This issue has become quite serious, and some of the reasons really given are based on avoidable and unsubstantiated reasons. And then this pattern has had a compounding effect on our system, as it contributed directly to the growing backlog of cases and unnecessarily prolonged the resolution of dispute. The consequences of this are quite significant, and they affect both employers and employees who rely on a fair and timely resolution to move forward. In some instances, cases have been postponed multiple times over several months or even years, which deeply undermines the integrity of our labour justice system. And as a nation, we must remember that justice delayed is justice denied. And this directive is one of the measures we have introduced to address that.
Now, from your perspective, what are the main reasons parties usually give when requesting postponements, and why are these now being restricted?
Common reasons provided include lack of preparations, that parties, when they come to arbitration proceedings, they will say, no, we cannot proceed today because we are not prepared. Unavailability or change of representatives, late engagement of parties with their representatives, legal practitioners being engaged in the High Court, forgetting the date of the hearing, double booking, or citing personal commitments. While some of this may appear reasonable at face value, they have increasingly been used repeatedly or strategically as a means to delay proceedings. This has created an environment where postponements are almost expected rather than exceptional. So by restricting these types of reasons, the directive aims to discourage abuse of the process and instead promote a culture of better case management, accountability, and preparedness among all parties involved.
Now, the directive states that no postponement will be granted due to a lack of preparation. How do you balance this strict stance with ensuring fairness for both employers and employees?
The directive is not intended to be punitive, but rather to enforce a greater sense of responsibility and accountability. Our parties are given adequate notice and sufficient time to prepare for their hearings. And this new approach encourages them to treat the process with the seriousness and urgency it requires. At the same time, the principle of fairness remains central. So the directive still allows for postponement in exceptional, compelling, and justifiable circumstances. When this is implemented, it will ensure that genuine cases of hardship or unforeseen events such as emergencies or circumstances beyond a party's control are still given due consideration. In this way, the directive maintains a necessary balance between procedural efficiency and fairness to all parties involved.
Can you tell us how will this new enforcement impact ongoing cases that are already in the system?
Ongoing cases will now be subjected to the same standard, meaning that any future postponement requests must meet the threshold of exceptional and justifiable circumstances. However, this directive does not apply retrospectively, meaning that previous granted postponements will remain unaffected. The aim is really to bring all cases, regardless of their stage, into alignment with this renewed focus on efficiency, discipline, and accountability. And we must also consider the human element. Some parties travel long distances, and most of the time at greater personal and financial cost, only to be informed that their matter has been postponed. This is not justice. Therefore, this directive seeks to ensure that such situations are avoided and that the system respects the time and circumstances of all who engage with it.
And just finally, how does this move fit into the broader goal of restoring confidence and efficiency in Namibia's labour justice system?
The Office of the Labour Commissioner plays a pivotal role in Namibia's labour landscape. It serves as a port of entry for all labour disputes in the land of the brave. Therefore, it is essential that the processes under our purview are efficient, credible, and fair. By limiting unnecessary delays, this directive supports a more predictable and effective dispute resolution process. It also enhances the credibility of the system by demonstrating that we value the time, the effort, and the rights of all parties involved. This move forms a part of a broader reform agenda, which is to build a labour justice system that is responsive, trustworthy, and accessible to every worker and employer in Namibia. And as we are also planning to have our standard operating procedure, postponement is one of the aspects that are addressed in that standard operating procedure. And the media will be informed when we are about to kick